This is one of the programs that we do on a somewhat regular basis. We're in our 44th year of free enterprise advocacy and education. We're proud to be coming to you today from our EL Wiegand Conference Center in our headquarters in DuPont Circle area of Washington, D.C. This is the residence of the daughter of Teddy Roosevelt, Alice Roosevelt Longworth, whose spirit infuses WLF's work just about every day. The work that we do is focused around principles of free enterprise, due process, First Amendment rights, other issues. You can learn much more about us on our website. Introduce the program, and then we'll get started. One general principle behind the First Amendment is that the speech clause makes it easy for us to speak and hard for government to suppress our speech. The opposite is unfortunately true when it comes to product liability litigation, accusing a manufacturer of failing to warn of a risk, and in civil consumer deception claims under which a product maker is accused of saying too much. In those instances, it's hard for business entities to speak and easy for speech to be punished. How can it be that private plaintiffs, or in some instances government plaintiffs, can sue litigation, can use litigation under broad statutes and common law concepts to restrict or mandate speech in a manner that would never pass muster if done by government regulators? Can targets of such suits argue that a jury verdict or a court ruling constitutes state action sufficient to trigger constitutional scrutiny? These are big concept questions. So we are pleased to have with us today two attorneys who are not only big thinkers, but also apply their creative thinking on the First Amendment and civil litigation on behalf of grateful clients. Before we get started here, I wanted to note that the program is being recorded. If you'd like to download the slides that are being used, you can click on handouts. Let me go ahead and introduce our speakers. Our first speaker will be Rob Weiner, who has a significant experience as a trial lawyer, appellate advocate, and legal strategist in complex litigation as senior counsel at Arnold & Porter. He's skilled in developing creative legal approaches from bringing cases to quick, cheap, and successful resolution. From 2010 to 2012, Mr. Weiner was Associate Deputy Attorney General at the U.S. Department of Justice. He also served as senior counsel in the White House Counsel's Office and as an Associate Independent Counsel. He began his career as a law clerk for the Honorable Henry J. Friendly and for Justice Thurgood Marshall. Speaking second today is going to be Trent Norris, who is also with Arnold & Porter as a partner in their San Francisco office. He's one of the foremost consumer product attorneys in the country and co-leader of the firm's consumer products retail and retail sector. He's argued dozens of cases before the California Court of Appeal, California Supreme Court, and the Ninth Circuit. Common opponents include activists and environmental groups, the California Attorney General, California District Attorneys, and plaintiffs' lawyers. Rob, if you could get us started.
Thank you, Glenn. It's a pleasure to be here. Trent and I have done a lot of First Amendment work, and both of us have come to believe that the First Amendment is underestimated and underutilized as a defense in a range of cases where plaintiffs are challenging speech by corporate defendants. So let me move to the agenda in which we're going to discuss the usefulness of the First Amendment as a defense in cases involving corporate defendants. First, we'll review the legal advances, and if we could get the slides there. First, we'll review the legal advances in First Amendment protection, and I'll do that. Then Trent will talk about regulatory compelled speech cases and the litigation that he's handled under Proposition 65. I will then cover the potential for a First Amendment defense in private product liability and consumer litigation, and then we'll leave time at the end for questions and discussion. So there has been an uninterrupted expansion of protections for commercial speech for 30 years, a steady march from the Central Hudson case, which adopted intermediate scrutiny for restrictions on commercial speech to Sorrell, which suggested a higher standard, Expression's hair design, which struck down on First Amendment grounds a law that barred merchants from giving a cash discount, and most recently, NIFLA and Janus, two cases which make clear that the First Amendment also provides strong protection against efforts to compel all sorts of speech. Now, the reaction to these developments has been telling. You have the NIFLA dissent, where Justice Breyer said that the decision there threatens the constitutional validity of much, perhaps most, government regulation. Justice Kagan in Janus accused the majority of weaponizing the First Amendment and unleashing judges to intervene in economic and regulatory policy. Left-leaning academics have sounded similar alarms, using terms such as First Amendment Lochnerism, Adam Smith's First Amendment, and most recently, First Amendment imperialism. So let's start with the central Hudson test. That was announced in 1980, and the threshold of that test was that the speech had to be not misleading, and this is for commercial speech. And if it was not misleading, then the government had to show that the restriction that they were imposing directly advanced a substantial government interest and was no broader than necessary in doing so. In the Sorrell case in 2012, the court tightened that standard. Vermont had restricted pharmaceutical companies that were marketing their products, but it hadn't restricted insurers or others in what they could say. And the court said that the restriction there was based on who was speaking, what they were speaking about, and the positions that they were taking. The court suggested that such restrictions are subject to strict scrutiny, although they didn't definitively decide the issue because the Vermont law failed the central Hudson test. And I say I tried that case. Central Hudson remains alive and well in some lower courts, but just recently the Sixth Circuit, in a recent case, has suggested that where a restriction is content-based, strict scrutiny applies even where the speech is commercial. And I expect that there could well be a majority of the Supreme Court that would accept that position. Now, one more development before we talk to how these principles apply, the concept of chill. And under the First Amendment, you get relief if a government requirement discourages your free speech, even though it doesn't actually require or forbid it. So a vague standard, for example, may deter more than intended because companies do not want to risk liability on close calls. Central Hudson said that chilling effects were not an issue for commercial speech, but cases since then have treated the doctrine as applicable and provide some support for a chill argument. So with that, I'll turn it over to Trent.
Thanks, Rob. So I'm going to talk about regulatory compelled speech cases. The government is forcing a commercial entity to say something which the entity would rather not say. And first, let me give a brief overview of some of the current case law in this area. And then I'm going to want to drill down into California propositions, commercial entities who sell products in California. The first of the cases by background is American Beverage Association versus San Francisco. San Francisco, in its great wisdom, decided that consumers need to be warned that drinking sugar-sweetened beverages fat create diabetes and it may contribute to tooth decay. And they passed an ordinance requiring that 20% of any bill of San Francisco's message. American Beverage Association sued to challenge that. Case was ably argued ultimately in the Ninth Circuit and is still ongoing by Rick Bress of Latham & Watkins. And they won in a Ninth Circuit decision that agreed that 20% was too much, but they would give guidance even as to whether 10% was too much of a burden on the speaker. That's one of a pair of cases that the Ninth Circuit heard around. The second one to do with cell phones and the radio frequency waves from cell phones. The city of Berkeley across the bay, from there be a poster displayed in any store that sells cell phones that displayed the one shown here to indicate to consumers that there was information about how to use their cell phone to stay in compliance with federal guidelines, which would be found. This case went the other way, and the city of Berkeley prevailed in the case with a circuit ruling that the information provided here was truthful and was not misleading and was to federal guidelines, and therefore it withstood First Amendment scrutiny. Also, it was key in this case that the commercial entities could say whatever else they wanted in conjunction with this warning, but they had to display the warning itself. Supreme was being decided, and this case had to do with abortion, and it may go into the category of cases, but nevertheless, it reiterated the principles here. This was a case against California, which had required this particular warning on family planning clinic doors services. And here, the California lost this case, and the warning was struck down by the U.S. Supreme Court. So what was happening in all of this was an application of the Zauderer test. Rob talked about the central Hudson test, which applies to commercial, applies to compelled commercial speech and what restrictions the government must meet in order to require a statement by a commercial speaker. It must be purely factual and uncontroversial. It must be reasonably related to a substantial government interest, only to avoid fraud in the commercial transaction that was being proposed, but now has been extended beyond that. And it must be neither unjustified nor unduly burdensome. The burdensome side of it was where in the American Beverage Association case, but NIFLA may have altered this. It certainly put a gloss on it, which made it clear that the government bears the burden of proof to justify the restriction on the speech, and that perhaps merely requiring the entity to speak alters the content. And so there's a big debate as to what level of scrutiny ought to apply in these types of cases of speech. That said, placing the burden on the government is in itself a significant development to make clear that the government must come forward with it. With in mind to talk about Proposition 65. First, some brief background on Prop 65. It's been around the U.S. Supreme Court in 1985. Prop 65 was passed in 1986. It's a statute. Chemicals go on the list. There's almost 1,000 of them on the list. And they go on the list based on animal studies. If they are shown to cause cancer or reproductive toxicity in animal studies, being on the list is extraordinarily low. Then if it's on the list and it's present in a product sold in California, then you must provide a warning for it unless you as the business are able to prove, so you bear the amount of the chemical to which the average consumer is exposed causes no significant risk. And so the burden shift is a key component of Prop 65. It was justified by the proponents of the law on the basis that business safety of chemicals that they put into their products. But much of the litigation in Prop 65 is not about chemicals put into the products, but rather contaminants that are present, for instance, in the food supply, because there are heavy metals in the Earth's crust find their way into food, or chemicals are created in cooking food. The warning is, warning, consuming this product can expose you to the chemical, which is known to the state of California to cause. And so it compels a message, it implicates speech, and the First Amendment applies. In the Prop 65 world, we have thought for decades about how the First Amendment might work here. And twice now, the issue has been litigated in an enforcement proceeding in a defensive posture. In that posture, you're almost there in the courtroom in an orange jumpsuit, and your lawyer making some Ivy League argument to a judge who doesn't want to hear all the complications of it and is more likely than not to deny the motion, the First Amendment, and instead proceed on to the liability phase. So many Prop 65 cases settle. Very, very few go to trial as a result of that. So enter a major controversy around glyphosate and Roundup. Glyphosate was added to the Prop 65 list automatically because the International Agency for Research on Cancer, alone among agencies and scientific bodies worldwide, had determined that it causes cancer and listed it as probable. So it went on the Prop 65 list automatically in 2017. And Monsanto, the inventor of Roundup and the molecule glyphosate, and producer of the product, sued to enjoy glyphosate under Proposition 65. They retained, and I was pleased to be his co-counsel in this case. And ultimately, we succeeded in obtaining from the Eastern District of California a permanent injunction, which has now been appealed to the Ninth Circuit. In this case, the attorney that warning, which I displayed earlier, could in fact have been revised. Prop 65 does not require those. You're at great risk if you use your own words to create a warning that the state would decide is clear and reasonable. Two very vague words not defined either in the statute or in the regulations. And so the standard warning, which is prescribed in the regulations as a safe harbor, is what's typically used. Was A, you can come up with some sort of warning that conveys factual information, and B, there's never any certainty in science. And so if the court were to rule in favor of the wheat growers and Monsanto, then against the regulatory state in general. We were able to show that the IARC decision, and therefore the listing under Prop 65, was an extreme outlier among scientific entities, that this was certainly not purely factual and uncontroversial. So this was the first Prop 65 case in which the First Amendment argument succeeded. It was by the way, had gone into effect. So before there were any warnings underway. What's happened then since then is acrylamide is another, which is found in many food products, almost anything that's plant-based and cooked, particularly at high temperatures, French fries, potato chips, black ripe olives, cookies, crackers, cakes, pastries, etc. are all acrylamide. There have been hundreds of lawsuits over acrylamide in these products, requiring the companies either to put a cancer warning on them or to reduce the level of acrylamide in the product. So the California Chamber of Commerce, which has several members who make these types of products and follows proposition and has been actively advocating for the business community for more sensible application of Prop 65, decided to sue and attempt to block further enforcement of Prop 65 as to acrylamide warnings. This slide here shows the products that are common targets and the huge uptick in acrylamide notices. These are brought by private and economic incentive for them to get into these cases, and to date, every acrylamide case has settled. There's a reduction in the amount of acrylamide permitted in the products, which is very expensive to implement. And if the company's unwarning, which nobody wants to put on their food product, a cancer warning, and money, of course, is paid to the bounty hunter and to the bounty hunter. So we retained our firm to challenge the acrylamide warnings. The evidence that we are presenting in this lawsuit, also filed in California, in Sacramento, is the overwhelming evidence that dietary levels of acrylamide do not cause cancer in humans. And for this, although the state bears the burden of showing that the warning is factual and uncontroversial, in fact, purely factual and uncontroversial, we have put in evidence to make it very clear that this warning is either epidemiological evidence and toxicological evidence, that the level of acrylamide in the diet is nowhere near the level that might create a cancer risk in humans. In fact, the American Cancer Society and the National Cancer Institute's position, we think that's a very helpful fact. And not only that, but 30 years ago, under deposition, the head scientist at the state agency that administers Prop 65 admitted that the state does not know that acrylamide causes cancer. You'll recall it is listed because it is known to cause cancer in animals, and that's typically at very high doses. But if the state does not know that it causes cancer in humans, why is the state requiring a warning that says this product contains a chemical known to the state, and that would be on food products? So the case has had a one-year timeline so far. Unlike in the wheat growers case, in this case, the Attorney General filed 2 motions to dismiss. And in addition, there was intervention from one of the many back who has intervened in order to stay on the side of the Attorney General in the case, and a motion to dismiss, and more recently a motion for attorney's fees, and a motion now for summary judgment, all of which are set. The motion for summary judgment is set to be heard on December 11th alongside our motion for preliminary injunction. So that motion includes the evidence that I mentioned before, a consumer's takeaway as the meaning of the warning that eating this product will increase their cancer rate, on which the court could grant the preliminary injunction following the hearing on the 11th. And one good example that we're on the right track here is that 2 of the leading activists who have supported Prop 65 and enforced it for many, many years, including the co-author of the approach, and have noted that it's very clever and that it could be a very effective argument against Prop 65 warnings in an appropriate case. So how has the Attorney General defended? Well, so far their defense has been, their defense will be that you cannot have enough certainty on this, and so the state should not be held to absolute factual statements, but instead ought to be able to make statements based on presumptions about the science. We think that's we expect that they'll be arguing that the warning, that a different form of warning could be provided. That argument succeed in the wheat growers case, and we don't expect it will succeed here either. So that's the story in Prop 65 of an effective means of restricting the application of Prop 65, at least where the science is on our side. We believe the state would have great difficulty in carrying the burden that is placed on it by NIFLA and other cases to justify the warning and to show that it's standard and purely factual and uncontroversial. With that, I'll turn it over to Rob to talk about private litigation. Rob, I think you're on mute.
Yeah, you're on mute, Rob.
I probably sound better that way. I'm going to cover three principles. One is why I believe that the First Amendment protections extend to private tort and consumer protection litigation. Second is the need to avoid, the tactical need to avoid overreaching when we assert a First Amendment defense. And the third is the way we avoid overreaching by deploying limiting principles and advocating for limited application of the defense. Now, while I'm evangelizing on this issue, I do want to say that I believe my arguments reflect a fair reading of the existing case law, but it is an extension of that case law into related areas, and there is no direct precedent on point. So this is an opportunity to make new law, and I think it's a very good opportunity, but you have to be judicious in choosing the forum and the judge. Now, how do these legal principles apply? The first important point is that warnings are speech, and a failure to warn claim either restricts speech or it compels speech. Same is true for overpromotion claims. The issue in those cases is what you said, what you should have said, what you shouldn't have said. Those are the issues. It's all about speech, and it's subject potentially to First Amendment review. Now, you may say, if you're skeptical, the First Amendment bars the state from interfering with free speech. And we're talking here about cases that are brought by private plaintiffs. But the purpose of a lawsuit by a private plaintiff is to enforce a state law duty of care or some other duty, whether it's a statutory duty or a common law duty. And just as that proposition means that those state law duties are subject to preemption under federal law, the enforcement of the duty also implicates the First Amendment. And as the court stated in the famous libel case, New York Times versus Sullivan, as you see here, the test isn't the form in which the state powers has been applied, but whatever the form, whether in fact the power has been exercised. Now, it is actually not novel to apply the First Amendment in tort cases. It's applied in libel cases, but also in cases involving intentional infliction of emotional distress, interference with business relations, invasion of privacy, and even in a few products liability and negligence cases, primarily where speech is the product, such as a do-it-yourself book. But I think you can extract from libel law principles that would govern here in a case involving products liability or consumer protection. The leading case in libel law is Gertz versus Robert Welch, which involved, unlike the New York Times case, a plaintiff who was not a public figure. And The principles you can draw from that case and its progeny are, for example, that the plaintiff cannot advance a vague claim, that they must specify the warning they say is required, that they cannot challenge an opinion. Gertz said that there's no such thing as a false idea. And if you can't challenge opinions, or as Trent said, you can't challenge controversial propositions, then that can have a significant effect on cases where what you said or should have said in your warning, or where in your warning you should have said it, may be a matter of opinion. Gertz establishes that you can't have liability without fault. Now, it is true that in failure to warn cases, the standard is really not very different from what the standard would be in a negligence case involving foreseeability, but that's not true everywhere. Gertz establishes, because they said you can't presume damages, that you can't take shortcuts via presumptions. And one of the important presumptions in a failure to warn case is the heeding presumption. And Gertz establishes that you can't have punitive damages absent knowing or reckless falsehood. That may not have an effect in all jurisdictions, but it may have an effect in some. Now, with regard on the ban on liability for opinion in controversial subjects, one area where defendants can argue for special solicitude is debates on science. Now, to the extent there is a general scientific debate on an issue, such as the toxicity of a product or the side effects of a drug or the crashworthiness of an automobile, the manufacturer's statements are more likely to be opinions and almost by definition will involve a controversial issue. Now, added to that, there's a strong public interest in encouraging debate on scientific issues. Chilling one side or the other of the debate will impede progress, which really depends on the dialectic give and take between scientists. So how do you know whether there is a genuine scientific dispute? It's not just because you and the plaintiffs disagree on the subject. I think one reliable standard might be whether there's disagreement in studies published in peer-reviewed journals. There may be other standards as well. Now, if the warning is speech, and if the rule of law the plaintiff seeks either forbids and impels it, then, or compels it, the First Amendment shifts the burden to the plaintiff to show, if it's strict scrutiny, that the restriction is narrowly tailored to serve a compelling government interest, or if Central Hudson still applies, that it directly advances a substantial state interest and is no broader than necessary. And one of the advantages of the First Amendment defense is that it shifts the burden, it reallocates the decision-making authority between the judge and the jury on that burden. So the determination whether the rule of law the plaintiff seeks to apply is narrowly tailored or serves a compelling or substantial state interest is for the judge. And a number of other threshold issues may also go to the judge instead of the jury. One that may be important is the threshold issue I mentioned before under Central Hudson, whether the statement is misleading or not. Now, Central Hudson suggests that if the statement is misleading, that's the end of the inquiry, and you still would get an advantage by having that threshold determination made at some level by the judge. But I think, particularly as the law has evolved, the issue is not that simple. The court said in Gertz that punishment of error runs the risk of inducing a cautious and restrictive exercise of the constitutionally guaranteed freedoms of speech and press, our decisions recognize that a rule of strict liability that compels a publisher or broadcaster to guarantee the accuracy of his factual assertions may lead to intolerable self-censorship. So there may be a right to be wrong, that a genuine and legitimate position held on a disputed issue may be sufficient to protect you. And the point about the right to be wrong was brought home with particular force in United States versus Alvarez involving the Stolen Valor Act. That act made it a crime to falsely claim that you've received a military medal. That the Supreme Court said that those statements were protected by the First Amendment. The case is obviously distinguishable, but it does establish the proposition that falsity or less misleadingness, for lack of a better word, does not wipe out First Amendment protection. And the right to be wrong is particularly important when we're talking about scientific debates. Another advantage of the First Amendment defense is that it may allow you to take advantage of the rule of constitutional avoidance. You don't have to get the ball over the goal line and demonstrate definitively that there's a First Amendment violation. You just need to get close enough that the court can invoke the rule, that it will steer clear of steps that raise serious constitutional questions. But going to the second principle, I think the most important pitfall in making a First Amendment defense is that you cannot and must not overreach. If a judge believes that your argument will gut tort law, that it will insulate bad actors from liability, and that it will leave injured plaintiffs across the board without any recourse, you're going to lose. The lawyer arguing the issue may confront hypothetical after hypothetical where the judge seeks to explore the implications of this defense, and therefore it is essential to articulate some limiting principles. And here are some possible examples. Under NIFLA, the law can require that your client make purely factual, non-controversial disclosures. A matter that is controversial is the flip side of the principle there, that controversial issues cannot be the subject of compelled speech requirements. A matter is not controversial merely because you and the plaintiff disagree on it. Second, finding that the First Amendment protects the speech at issue doesn't end the inquiry. Plaintiff can still recover if she shows that the rule of law at issue directly and narrowly advances a substantial government interest, or alternatively that it's narrowly tailored to advance a compelling state interest. I said there can't be liability without fault. The converse then is also true. There can be liability in many cases with fault. Punitive damages are not forbidden. They can be awarded on a proof of knowing or reckless falsehood. And importantly, recognizing the First Amendment here doesn't threaten regulation. In fact, the regulatory context provides a good counterpoint. When the FDA regulates a product label, for example, it engages in an elaborate process with people who have extensive expertise. Determinations about labels in product liability cases are made by lay juries deciding whether a seriously injured plaintiff is going to recover as advocated by a lawyer who may engage in the utmost histrionics to appeal to that sympathy. And that in and of itself is problematic from a First Amendment perspective and from a chill perspective. So let me address some of the counter objections that plaintiffs may advance, or which you may be mulling in your own mind. First, the plaintiffs will argue that it's imperative that manufacturers tell doctors or consumers about hidden dangers with their product. I contend that the defense doesn't interfere with that imperative. The plaintiffs will argue that warnings don't need First Amendment protection. Maybe not, but scientific debate does need First Amendment protection. And plaintiffs will tout the state's substantial interest in health and safety. But that presupposes that the rule of law the plaintiff advocates is necessary to achieving product safety or is even effective in doing so. It's sort of like when the American trial lawyers renamed themselves the Association for Justice a few years ago. It sort of assumes the conclusion. So the bottom line here is that this is not a magic bullet. It can advance the defense position, but it will not make every case go away. And while I recognize that discipline is hard to come by in the laissez-faire world of litigation defense, it will be important to pick the first cases carefully, focusing on the facts, the judge, and the circuit. But if we do that, I believe that this defense has potential not only in the state actor cases that Trent was talking about, but also in private litigation involving failure to warn in torts and consumer protection litigation. And we're open for questions.
Thank you, Rob and Trent. Again, if you have any questions for our speakers, you can type them into the chat function by clicking on Q&A, and I will present them to the relevant speaker. So I'll start off with a question for Rob. What do you think would be a sort of ideal first factual situation for a defendant to raise this kind of defense in a failure to warn case? Obviously, there's factors that you mentioned, such as where you can bring them that may be unknown, but are there factual situations, types of cases that you think are good ones to think about?
I think the ideal factual situation would involve a defendant in a regulated industry where you have a product like glyphosate that Trent was talking about, or a drug that the agency, through its careful deliberative process, has found is safe, and in which there may be a few peer-reviewed studies attacking the product, or not peer-reviewed studies, but a lot of peer-reviewed studies reaffirming its safety. I think in that circumstance, you have an argument that to compel the plaintiff, compel the defendant to take one side in that debate would interfere with the scientific debate that is necessary for progress, and that would infringe the First Amendment rights of the manufacturer to take a position in that debate which is legitimate and has scientific support.
Is there a place in what you're discussing for the point that's actually even made in the statement of third comments that there is a risk to overwarning?
Yes, I think there is a risk to overwarning. And I think that's one of the factors that could be considered when you're considering the state interest that would offset the First Amendment violation. If there's already an adequate warning, or if the warnings would be overladen with verbiage, then I think that there's a good argument that it does not adequately serve the state interest sufficiently to justify the imposition on First Amendment rights. I think overwarning also comes in a sort of crowding out argument, where if there is a difference, and I'm not sure there is anymore, between compelled speech, the standards for compelled speech, and the standards for restrictions on speech, you can generally convert one into the other by making a crowding out argument. If I make these warnings, say everything the plaintiff wants me to say, then I won't have room to say the things that I think I need to say.
And Glenn, I would add on the overwarning point. This is a point we've made in the acrylamide case. very pointedly, because this would require warnings on all sorts of food products. And the FDA even is on our side here in saying that it's concerned that people will alter their dietary habits in ways that are unpredictable and potentially bad for nutrition.
Thank you, Trent. Question from an online viewer. Can you discuss the debate over the suggestion in the NIFLA case that a compelled speech regulation is content-based per se?
Trent, do you want to take that, or you want
why don't you start first, because I mentioned it first.
I think that this is one of the concerns that the defense cited in NIFLA, that that a warning or compelled speech is almost always going to be content-based in some respect, because or speaker-based, because it's picking out a particular participant in the industry and saying that they have to make disclosures. I think that there I would argue that not every warning is necessarily a content-based restriction, because something that it applies across the board that is neutral but still content-based. You could have a warning that applies to all sorts of different products that says all kinds of products that do a certain thing must warn of particular dangers. I think that would have a much better chance of saying that's not content-based, although you can make an argument that it is. Again, I think you have to look for limiting principles and not take the position that every type of warning is per se invalid, or that you can construct such an argument, but I think it will lose because it proves too much.
Trent, do you have anything you wanted to add?
Yeah, the one thing I would add on it is, that's clearly, if you're reading the tea leaves right, that's where the Supreme Court is moving, is in the direction of scrutinizing these much more closely. And whether you call it intermediate scrutiny or strict scrutiny, the burden is certainly high for those who are trying to compel a warning, for instance, whether it's a private plaintiff or a government body.
I think the Supreme Court has not ruled against a commercial speech case in 20, 25 years, to my knowledge. And I suspect that however these cases fare, the cases I'm arguing for this defense, however they fare in the lower courts, I do believe that if you can get one to the Supreme Court, it will be decided in favor of the defense, if it's the right case in any event.
So one of the questions I've always had about commercial speeches is what constitutes commercial, and arguments have certainly been made that warnings that are being sought under consumer protection laws, or warnings that are being imposed by states on producers under laws like Prop 65 don't have a commercial message in them. You see any point where that's going to be a winning argument for defendants, or is this commercial so broadly defined now that it's not going to be helpful?
Well, commercial is defined differently in different courts, and the most favorable definition of commercial is a statement that proposes a commercial transaction. That's the one I always try to use if I can, because that's fairly narrow. It can't be that a commercial speech is any statement made by a profit-making entity, because that proves too much, and all sorts of things, like by Hobby Lobby would be included as commercial speech, which clearly aren't. So I think that if something advertising, it would be hard to say is not commercial speech. And advertising may be one of the narrow areas where the Zouderer case still applies, but it may not be. So I think there are courts that will take a very broad definition that approach almost anything said by a commercial entity, but I do think there are grounds to argue for the narrower definition.
Well, in that regard, the old case of Nike versus Kasky is instructive when you look at how the California Supreme Court decided what was commercial. In that case, Nike's issuance of press releases, which all had to do with refuting allegations of human rights abuses in the production of their shoes, the California Supreme Court decided that was commercial speech because, of course, Nike's goal is to sell more shoes. It was not speech on an interest of public concern and therefore political speech. And some of you on the call may recall that the U.S. Supreme Court first granted cert in that case and then later dismissed it as having been improvidently granted with a dissent from Justice Breyer that was very concerned about the application of false advertising laws to this type of speech that is being made by a commercial entity, but that is not merely proposing a transaction, but instead speaking out and defending itself, for instance, in a public relations manner. So how that works out, I think where the U.S. Supreme Court would go today is more clear than it was then as to how that might be resolved.
Rob talked about the use of the First Amendment in private liability type cases. Are there similar uses in consumer deception suits, such as the ones that you've been involved in quite a bit out in California, where, say, a company says that its product is healthy, they get sued because there's a lot of sugar in it. Their statement could be objectively true, and this allowing them from making that kind of a statement could impinge on their First Amendment rights. Are there arguments to be made there?
Yeah, absolutely. There are. Now, finding clients who want to actually litigate those issues is a little bit tougher. And, the deck is stacked against you, particularly if you're talking about state court cases in California. Again, it's, one of the things I think we discovered in the wheat growers case was how much more effective it is to bring an affirmative suit to stop that form of regulation than it is to be in a defensive posture. And, where judges, I think, grow weary of, well, if you don't like that argument, Your Honor, how about conflict preemption? How about interstate commerce clause? How about, but that said, I think the precedents are clear, the ones Rob talked about, Sorrell particularly, and others in that line of cases about the ability of commercial advertisers to emphasize one side of a scientific debate and not be required to display the other side of it necessarily in that regard. So, yeah, I think these cases the plaintiffs are on shaky ground in them, but they have enormous leverage just in the way the cases get brought and the economic side of it for the companies that are having to defend themselves.
And it probably will be easier to bring an affirmative case where there's a state on the other side because you can predict, for standing purposes, you really need to show that there's a risk that they're going to act. States usually signal what they're going to do. But there are circumstances where private parties do that as well. They send demand letters, or they even send class action demand letters, which might enable a client to bring an affirmative suit to preempt the suit that the tort suit that the plaintiffs would prefer to bring.
Another question from a viewer in the context of what we've been discussing here, the importance of scientific debate and the dangers of chilling debate. That reminds me of the central argument you made in Sorrell about Vermont attempting to tilt public debate in one direction. Has that argument that states cannot tilt public debate been elaborated in later SCOTUS or lower court cases?
One of the great presents the Vermont legislature gave us in the Sorrell case was they had a legislative finding that the marketplace for ideas was skewed and needed to be rectified. And, that's just inimical to the idea of the marketplace of ideas, period. I think that I did a study once for a client on the courts, the court's focus on paternalism, and there is no more effective argument, I think, with this court and with many courts than being able fairly to characterize a restriction or a compulsion as paternalistic. The direct question you asked about the effect on science, I think that's an argument that has legs in some courts and not in others. Clients make it all the time. It's true, but it doesn't always get a sympathetic hearing. It's still worth making.
Another question from an online viewer. Suppose a warning on a new drug is scientifically disputed at the FDA. Could the sponsor of the product use the First Amendment to challenge FDA's label requirement if they end up imposing the requirement that's in dispute even within the FDA itself?
That's a good question, and FDA is very worried about that question, because the FDA doesn't necessarily rule on the truth of the statement. And, the First Amendment really bars governments generally from prohibiting you from making true statements. And the FDA says, well, you can't make a claim about a product unless there are two well-controlled studies. Well, the statement may be true and yet not subject to two well-controlled studies. On the flip side is the proving too much problem that I think courts are going to be reluctant to go with any argument that completely guts FDA regulation. And so there would have to be a limiting principle. For example, the existence of a bona fide dispute within FDA. So I think that is a case that still remains to be brought.
Yeah, and I think where the action may be headed in the future is warnings that or disclosures that say on the one hand and on the other hand that describe a controversy. For instance, this is something the Attorney General thinks may be relevant and may work as a Prop 65 warning. We actually don't think it would comply with Prop 65 and its requirements. Whether it would, comply with the Zotterer standard is another question. What is the government's interest in telling consumers there's a controversy about a given issue? So that's the other part of the test on which that type of a warning may fall down. And I'll say the judges that have been presented with those options have been skeptical about that form of a disclosure of some sort.
Staying on Prop 65 for a minute, Trent, what does it mean in the law that and in the statements that have to be made on labels that California knows that a product causes cancer, and how does that sort of work into the First Amendment issues?
The Attorney General in the wheat growers case wanted the court to understand that known to the state to cause cancer is a term of art, and it means it's on the Prop 65 list. And it gets on the Prop 65 list not because California has tested it and determined that it causes cancer, but because somebody else has typically, and California just adopts that reasoning without any critical analysis of its own. In that case, Judge Shub said, consumers don't understand these words in the context of the entirety of statutes and regulations and that sort of thing. So it's one of the reasons why in the glyphosate case we did not have a consumer survey, but in the acrylamide case we did, in order to show this is what consumers think it means when you say on the label, this is known to the state to cause cancer. They think this is going to increase their cancer risk. And that's obviously the point of the statement.
In the wheat growers case, that was in the pre-enforcement seeking an injunction sort of approach. whereas in the Cal Chambers case, the Acrylamide case, you're looking at post-enforcement invalidation of the warning. How do those two different postures figure into the First Amendment arguments that are being?
Well, it's interesting. In the Acrylamide case, what we are seeking actually is a bar on new cases being filed, and this all is tied up in issues of abstention, the Anti-Injunction Act, even Norr Pennington has been argued against us. So we think what we're looking for is a ruling on this issue and a declaration that then may be applied in pending cases. But it's likely to be a two-step process whereby if we get the positive result we're hoping for in federal court, we could bring that result to state courts to have them stop the proceedings, perhaps even dismiss the cases.
Any final thoughts from either one of you? We've got out of questions here on the online. So,
Trent?
I would say, this is obviously, as the discussion shows, this is a defense to be considered very carefully in whenever speech is challenged or speech is at issue or speech is sought to be compelled. But even more importantly, to look at this in the context of an affirmative approach and a way to team up perhaps collectively through a trade association or otherwise in order to go on the offensive in these types of matters. I think that posture is, I'm far more optimistic about the results in that type of a posture.
And I would say this, in the private context, this defense has a long way to go. It hasn't really even gotten started yet, but I think there is some there. And the case law does support this kind of defense, and it is worth considering carefully and judiciously in the right courts. And if we can build some credibility behind it, even in cases where it doesn't necessarily succeed, it can affect the value of the case because it will pose a risk to the plaintiffs and therefore reduce their estimated costs. Right now, it may or may not. I think we need to build up some, but I do believe that we can do that if we do it carefully.
Thank you, gentlemen. Since we've been discussing fundamental freedoms today, I think it would be remiss of us not to, on this Veterans Day, say thank you to those who have given their lives and their time to protect our freedoms and the families of those that have done the same. Quick public service announcement, we're doing another webinar next Wednesday on the topic of online platforms, potential exposure to strict liability, failure to warn claims for products that are sold by third parties on their platforms. So certainly you can sign up to watch that one just as you did with this one. And thank you for everyone for tuning in. Thank you, Rob and Trent, for your outstanding presentations.
Thank you.